We're the moms who ask the questions, digging deep, no second guessing. From the school run to the crime scene, truth and chaos, we're the dream team. Bad Kids Club, yeah, we ride or die. Sad eyes sharp and our standards high. Brought together by FKR, now we're taking truth real far. And we're just getting started. Talk time with Amy, Boston, and Kelly, spilling facts that hit your belly. Partners in crime, fueled by conviction. Moms on a mission with sharp intuition. Talk time, we're calling out lies with caffeine, chaos, and sad-eyed vibes. It's raw, it's real, it's how we vent. Leaning close, let the reckoning commence. This is Talk Time with Amy, Boston, and Kelly, where the tea is.
I don't remember that. Oh, good. Oh, for sure, absolutely. Oh, right. This is yeah. Should be done well. So Jason has now finished numbering everything according to the question. Make sure this is this is 100. You'd like this to Yeah.
All right, court is now set and the Honorable Judge Stephen Everett presiding.
Morning, you can be seated.
Hi, Judge.
Here this morning in State versus Donna Adelson, 2023 CF 3226. For the final pretrial hearing this morning, we're going to address all of the outstanding motions and also some matters pertaining to the trial, which is still scheduled for the selection of the jury starting on August 19th. The parties can make their appearances for the record.
Georgia Kappelman for the state.
Jackie Fulford for Mrs. Adelson.
Joshua Zellman for Mrs. Adelson.
I believe we have several defense motions to address. Ms. Kappelman, the state has not filed any additional motions in limine that have not already been addressed by the court.
That's correct, Your Honor.
Right. Let's start then with the motion in limine concerning the court file relating to the dissolution of marriage. Mr. Zellman.
Thank you, Your Honor. Your Honor, as is my custom, I lay it out in motion. It's our position that the vast majority of the court file, even with the court taking judicial notice, is inadmissible. It's irrelevant. Paragraph 7 of my motion provides a somewhat comprehensive list of the items that are in there that have no bearing, have no relevance, they're not material in any way to this case. And so we're asking that, aside from very limited number of items that the state can establish has relevance, and it's not barred by hearsay, we're asking the court exclude that file.
Ms. Kappelman, which parts of this file is the state seeking to admit as a part of its case in chief?
The entirety.
Right. As to the items that deal with, as identified in paragraph 7 of the motion, what exactly would be the relevance first, and what is your argument as to hearsay?
For relevance, Judge, it goes to the motive, the level of intensity of this litigation, the volume of the paperwork suggests that it was very litigious and went on for some time. The words that are used are strong, even hateful, and this was a cause that was adopted by the defendant, as the emails evidence will show. So it's important for the jury to understand the foundation of this motive is this litigation that began with the divorce, continued beyond the divorce with the child custody issues that developed later.
All right. So in part, the volume of what occurred over the divorce proceedings, you want the jury to recognize this goes to motive in some way.
Yes, Your Honor. In reference to hearsay, the items are not being offered for the truth of the matter asserted. There obviously was a litigious divorce, but it's being offered to show the effect on Ms. Adelson. These items were shared with her. The evidence intends to show she was very involved in the pleadings. She was sent the pleadings and offered detailed responses for how Mrs. Wendy Adelson should respond to the pleadings. So it's very bound up in the state's theory of the motive for the case.
All right. Mr. Zellman, as to your client's emails to her daughter as this litigation was going on, are these contested in any way?
With respect to the initial dissolution proceeding, no. However, in reviewing the emails, the post-dissolution matters that were filed by Mr. Markell, there's no evidence in those emails that those pleadings were shared with Mrs. Adelson. And so certainly, if the state's theory is that it goes to the motive, and that's the way of getting around hearsay, they have to establish that the pleadings were sent to her. My review of the emails show that did not happen. So they can't go to show my client's motive if she didn't receive them.
All right. As to any pleadings that correspond with emails or communications that were made by the defendant and otherwise demonstrate her role in or some part in the divorce case, As to those, I'm going to rule they are admissible. The pleadings themselves, if they're being offered not for the truth of the matter asserted, but to otherwise demonstrate motive or intent, those are admissible. However, Ms. Kappelman, as to the bulk of the file itself, I do believe the defense is raising a clear point on this. Absent a connection or a nexus between the defendant and specific aspects of the divorce file, what is your argument concerning it?
I mean, there are pleadings in there that are not necessary to show the motive, but I did offer the exhibit itself in its entirety to demonstrate the bulk. If Your Honor is not inclined to allow those pieces of paper that cannot be directly connected to the defendant, may I be permitted to show the exhibit as a demonstrative to the witness to verify that that is the entirety of the divorce file?
It is permitted as a demonstrative. You may also ask questions that generally deal with the amount of filings and also the volume of the case, but ultimately as to responses for production or mediator notices, I'm inclined to agree with the defense as to that point. If there's not either a relevant connection or a nexus between the defendant's actions and then what occurred in the dissolution of marriage case, all of it does not come in as substantive evidence. But I do want to make clear on this point, Mr. Zellman, as to what the witnesses will testify to, and none of us will know this until the evidence actually begins. This file can be used for purposes of impeachment, and it can also be used for purposes of rebuttal. Depending on what the witnesses say, what might be not a part of the state's case in chief may still be available to them through other means that are permitted by the rules of evidence. Is everyone clear on those?
Yes, sir.
Yes, Your Honor.
All right, let's move on to the motion in limine concerning the testimony of Sarah Youssef. Mr. Zellman.
Again, Your Honor, we stand on the motion.
Ms. Kappelman responds.
I would just ask Your Honor to reserve on her. The state has no intention of calling her, so I don't think, unless that changes, that there's any reason to address her testimony at this time.
Well, and I assume you are going to leave Ms. Youssef available as a rebuttal witness if necessary.
Yes.
If the witness is not going to be called, it essentially moves the issue. On that point, Mr. Zellman, the state is not committing to calling this witness. If they do call them at that time, I will issue a ruling concerning your motion in limine.
Yes, sir.
As to any purpose of rebuttal, ultimately what comes out as a part of the defense case, Ms. Youssef still is able to testify in that capacity. Right, the next motion in limine concerning the testimony of Stephen Webster. Does the defense have any argument that has not already been made through the pleading?
No, Your Honor.
Ms. Kappelman responds.
Judge, I agree with some of the defendant's motions. I don't think Mr. Webster can offer opinions. For example, his testimony, of course, will be governed by the same rules of evidence that every other witness is governed by, but he does offer some relevant points. So I think I should be permitted to, I don't know, these motions kind of blow my mind because it's like we want to pre-litigate every statement, including potentially objectionable statements that can be addressed during the trial by a proper timely objection. So I would ask that it be handled in that way.
All right, concerning the testimony of Mr. Webster, Mr. Webster, in his capacity of representing the deceased, certainly can testify factually as to what his involvement was with the divorce case. And also, he may testify concerning the nature of the proceedings as to any opinions that go beyond that. ultimately, I think that's where we are going to have to get into what is being asked and what would be the response that ultimately the defense would find objectionable. But generally, as to any opinion that Mr. Webster cannot give without a proper foundation, I think it's settled as a matter of evidence that no witness gets to generally opine on matters in which they are not qualified to testify to. Is any other ruling being sought concerning Mr. Webster beyond that by the defense?
Well, yes, Your Honor. In prior trials and in deposition, Mr. Webster testified about statements made to him by Mr. Markell. Those are hearsay. There's not an exception. Those statements weren't shared with anyone else, certainly not my client. Those were statements that were made during the meeting in May of 2014 that Mr. Webster. There's no exception that I'm aware of under the hearsay rule.
Statements made by the deceased to Mr. Webster. Ms. Kaplan, do you have an argument?
I think I agree in general that those statements would be hearsay. I don't recall what my theory of admissibility was in prior trials, but I would agree to approach if I intend to elicit a statement made by Mr. Markell to his attorney and offer my theory of admissibility prior to asking the question. If I decide to do that in this trial, I don't think I plan to do that, so it's hard for me to address what that theory might be now.
Well, again, as a general principle of evidence, hearsay that has no exception is not admissible. If the state is seeking to admit this statement for a proper purpose that actually has a basis in the rules of evidence to be admitted, you will need to approach so that way the information is not placed improperly before the jury. The motion in limine is granted as to Mr. Webster offering any opinions for which he is not qualified to give. The court will reserve ruling on the issue of any statements that he may testify to by the deceased. If the state, again, will have to present an actual exception to hearsay in which the matter can be placed before the jury. Right, the renewed motion in limine concerning the Latin Kings. Mr. Zelman?
Yes, Your Honor. This goes in part to the theory of the defense and why Mrs. Adelson acted the way she did, the language that she used on the 2016 wire calls. Typically, I know that we would want to have the foundation laid through her testimony for that, but if the court were to bind our hands in questioning the state's witnesses, it would be too late to wait until she testifies. We would lose the ability to cross the state's witnesses on that issue. It's very limited. You have Luis Rivera. There will only be a few questions at most. Potentially Charlie Adelson, depending on when the state calls him. Certainly Special Agent I believe it's Jimenez.
Now, in the last trial, he outright testified that he was, I guess, at least pretending or trying to influence your client as a member of the Latin Kings gang.
Yes, sir.
All right. To that end, Ms. Kaplan, what is your argument?
Same as my argument has always been on this issue, Judge, which is that Rivera was a gang member. That's why he was recruited to do this. I think that's relevant. But the fact that he was a leader of a specific gang, I think is just bad character evidence that doesn't lend anything additional, more prejudicial than probative, and I would ask to exclude those details.
Similar to what we had in the last trial, as to this painting the character of Mr. Rivera specifically in a negative light, the court's ruling will remain the same. As to the witnesses, though, Mr. Jimenez or other witnesses that may bring up this topic unsolicited on their directs, once the horse is out of the barn, it's out of the barn. As far as any cross-examination of Mr. Rivera specifically, the defense may cross-examine Mr. Rivera as to his role as a gang member and why he was recruited into this matter to specifically serve a purpose as it relates to the conspiracy of the killing of Dan Markell. Now, with regard to undercover or the former undercover agent, Ms. Cattleman, this is where I believe the analysis begins to diverge on this topic. He specifically approached the defendant as a Latin King member, correct?
No, sir. My recollection is, I know that was his testimony, but I would instruct him not to say Latin King in the future. However, he didn't say anything to Ms. Adelson about being a Latin King. I guess that was his version of acting like a gang member. I don't know how well he did. Ms. Adelson didn't seem to think he did very well, but that was the intention. He did not represent himself to her verbally as a Latin King gang member. He was not wearing any clothing or other signifiers that he was a member of a specific gang. And the idea was just, you're an associate of this killer who is a gang member.
In response on that topic, Mr. Zelman.
Just looking at his previous testimony. My role, I'll quote from page 1067 of the trial transcript of Mr. Charlie Adelson's case. Starting at line 20, question, can you explain what that operation was? Answer, my role in that operation, I was portraying a Latin King gang member and I was instructed to conduct the one. Continuing on 1068, question is, all right, when you say you were posing as a Latin King gang member, did you announce yourself as a Latin King gang member to the person you approached? I did not. Okay. So that's the role. That was my role. You're a character. That is correct. That is his testimony. And I believe that once, especially with the call that my client made to the undercover on May 6th of 2014, when he became verbally aggressive towards my client, that factors into his role as a Latin King gang member. And I know in the previous hearing last year, Your Honor questioned whether there was a difference between a Latin King gang member and simply a gang member. The answer is absolutely. In Miami, in South Florida, there is absolutely a difference between a gang member and a Latin King gang member.
Even with that being said, this ultimately goes to your client's state of mind, who is going to establish how she knows the difference between, forgive the pun, the garden variety gang member and a specific gang member.
I think between her testimony and anticipated testimony of Charlie Adelson.
Well, as to the questioning of the former undercover officer or special agent Jimenez, I will permit the defense to question the former special agent as to whether he is portraying a member of a specific gang as a part of his own operation. Depending on what the answer is, we will revisit the issue of whether the name Latin Kings needs to be specifically uttered as to either Mrs. Adelson or Charlie Adelson testifying concerning her state of mind and knowledge of the Latin Kings. As it goes to state of mind, the defense may certainly inquire as to that during the defense case in chief. As to Luis Rivera, the court's ruling will remain the same as to his leadership role or specific affiliation. The fact that he is a gang member may be inquired into, and the fact that he has had or the fact that he had, or his role while he was recruited in this case, that certainly is ripe for cross-examination and may be inquired into. But as to him being a specific Latin king, that is where the line is going to be drawn. Do we need clarification on these rulings?
Just a moment, Your Honor.
Not from the state judge.
So the concern we have, Your Honor, is that Mrs. Adelson, part of her state of mind, her level of fear, is that it's not just that she learned he was Latin King, but that he was the leader of one of the branches of the Latin Kings in South Florida. That heightens her fear. And of course, she will testify to that.
I cannot make her testify. If she is committed to do so as a part of her defense, that's her choice. But ultimately, someone with competent knowledge has to testify to this fact. Eliciting information about state of mind from a witness that either has not spoken to your client or either has no knowledge of the state of mind, I'm not sure how that can be accomplished other than either your client herself, her son, or someone else who has direct knowledge of her state of mind at the time, unless you have an argument.
So I guess the way that we could accomplish that, Your Honor, is that Mr. Rivera, he is under a defense subpoena. We would ask that he remain for the defense case so that we can call him on our case in chief.
That's fine. Mr. Rivera, as I recall, never had any direct communication with your client, but this is to elicit another relevant matter.
That's correct, Your Honor. It would be, once we establish the foundation, I would want to recall him for the specific purpose of him confirming that he was a leader of the Latin Kings.
Very well. Mr. Rivera will remain under the defense's subpoena until the conclusion of the trial. Let's move on to the defendant's motion of limine as to the interpretation of emails, recorded phone calls, and text messages. Which witnesses is the defense referring to concerning this motion?
I think it goes really to retired Detective Isom, Special Agent Sanford, potentially Jason Newland. I think a number of witnesses have offered interpretation of statements that were made. Now, we're not talking about coded language. Coded language is treated differently. What we're talking about is the emails, the recorded phone calls, and text messages, other than coded language. What we're asking the court, because it has come out so frequently, that the court prohibit the state and, what's good for the goose is good for the gander, the defense, from asking someone other than an expert to offer an opinion about what someone means by an email, what they meant by a statement, or what they meant in a text message, aside from the language that's used itself.
Ms. Coleman, response?
I agree, that would not be admissible.
The motion in the limine is granted as previously raised in the argument on this matter. Any matters that would go to a code in which a witness could lay a proper foundation on this issue. Certainly, they may testify as to that point, but any general opining as to what an email, a phone call, or a text message means will not be permitted unless there is a proper foundation that can be laid by that witness. Next, the defendant's renewed motion in limine concerning travel as consciousness of guilt.
Your Honor, I know that the court previously ruled on this issue and that allowed the state to use this information in their argument. The new information, as I've laid out in paragraphs 4, 5, 6, and 7, I stand on the motion. Those additional pieces of information had not previously been provided to the court, and I think that it's significant because it goes to her state of mind for making the travel plans and for going to the airport and for stepping on the jet.
If I'm recalling our counsel's argument correctly, if Mr. Rashbaum did raise the fact that there was no legal process, subpoena or warrant for your client, correct?
I believe that's correct, Your Honor.
So, response, Ms. Calvin?
Judge, I don't think this is new information. This was never disputed. I don't think it changes the analysis.
On this particular point, the court has reviewed the transcripts of the depositions that were cited by the renewed motion. And the ruling will remain the same on this issue as before. These matters go to the weight of the evidence and not the admissibility. The jury, as the trier of fact, is going to decide what significance to give to the evidence. The defense also is free to cross-examine on all issues that pertain to Mrs. Adelson being free to travel. The matters that have been previously raised within the motion to suppress and rule on as to the phone calls and other evidence, that also will be presented to the jury as well. They will make up their mind.
Thank you, sir.
Well, I believe that covers the defense motions. And Ms. Calvin, you stated that the state did not have an additional motion of remedies that not have been previously ruled on.
That's correct, Your Honor.
Judge, there's one additional one also filed on July 21st concerning the opinion testimony of Jason Nolan and Patrick Sanford.
Yes. Go ahead with that motion.
Sorry, Your Honor. I'll stand on the motion.
Ms. Calvin, a response?
Judge, the defense elicited personal opinions of these witnesses at deposition about the lawyers and their ethics and how they think they might have been involved in the new investigation, and now seeks to suppress those opinions, which are clearly inadmissible. I don't understand it. I don't know why we're doing it. I would never elicit such a thing.
Well, Ms. Calvin, even though it might be inquired into in deposition, ultimately, if there's a basis to exclude it pre-trial, that's why it's being raised now.
Of course, there is no reason to elicit it at deposition, and it could never be admissible at a trial. So we're just wasting paper and time with these motions. No objection.
But the state is conceding the issue. The motion is granted as to any opinions that would be offered by either investigator Newland or Special Agent Sanford. Again, there must be a proper foundation for them to offer an opinion on a subject. If they don't have the ability to do so, it cannot be presented as a part of the case in chief. I don't really see a context in which this might come around, either in rebuttal or as far as impeachment, but again, these rulings are being made as to the state's, the substantive evidence the state may present as a part of its case in chief. If it needs to be readdressed as a matter of either impeachment or rebuttal, I'll take it up at the appropriate time. All right, let's go ahead and talk through some of the logistics for jury selection on 8/19. We are going to be in this courtroom once again. I believe the number of jurors that we have under summons right now, or prospective jurors under summons, I believe it's near 300. So what we're going to do on that Tuesday, essentially we will have the pre-screen of jurors on the issue of pretrial publicity, similar to what we did in the last trial. The court will be asking these same questions, or substantially the same questions. Both parties will have an opportunity to follow up on the court's questions on the issue of pretrial publicity. If a prospective juror is deemed suitable to return for a group voir, from there they will be given the date and time for which group voir will begin. For the pre-screening that will take place on both Tuesday morning, Tuesday afternoon, potentially Wednesday morning and Wednesday afternoon, I would anticipate by that point, we would have a suitable pool of jurors from which, going through the pre-screen process, anyone who has had an issue, or either the court believes, the state believes, or the defense believes, is not suitable to go to the group voir dire. From there, each party will have an opportunity to make their objections known as to that respective juror, and they'll be told to return, or they will be excused at that point. Does anyone have a question about the pre-screening process?
No, sir.
There you are.
Also, as well, so that we don't have any issues similar to what occurred in the previous trial, in which I believe there were allegations the jurors were speaking to each other. We are going to have additional bailiffs. The prospective jurors are going to be instructed not to speak to each other. It might make a long day for them, but they will be sitting in silence. We will provide reading material to them, and we will have extra bailiffs on hand to ensure that no one is speaking to each other while they're waiting to be screened. Does anyone have anything they need to raise concerning those?
Is it your honor's intention to handle the pre-screening, I don't know what it's called, instructions that happen down in jury assembly?
Yes.
Okay.
I believe last time, I'm not sure if someone else qualified or not, but for each group that will be qualified, I will do it personally, so that way from beginning to end, they are seeing me, hearing me, and understanding you're not to discuss the case or anything else with each other.
Perfect, that's the state's request.
Judge, how many of the 300 are coming each day?
Broken up into groups of 50, so 50 in the morning, 50 in the afternoon. We may not even need to get to the end of this grouping altogether if we are able to go through the pre-screening process on the issue of pretrial publicity. Once we have, say, 100 to 110, that's more than enough to give 12 people.
How do you intend to handle proceeding once we successfully select a jury?
Once we have selected a jury at that point, and also I believe too, we'll need at least 2 alternates unless the parties wish to have 3.
We defense would request 3, Your Honor.
Then once we have our 12 jurors and 3 alternates, at that point, we will swear them. If we have enough time to actually move into opening on that same day at the selection, we'll do that, so that way we can start to begin into witness testimony seamlessly without issue. How many days is the state anticipating to go through its case in chief?
I think best case scenario is 5, worst 7, so 6. I could see how it could run into the first part of the 7th day, Judge. I think 6 is a comfortable estimate.
Let me bring up my calendar. Assuming that we have a jury by Friday the 22nd, we know that in place August 25th through September 2nd as the state's case in chief. I think there is a holiday on September 1st, correct?
Yes, sir.
Yes, sir.
Is anyone volunteering to work on Labor Day?
Jackie is.
I need one other hand, unrelated to that side of the table.
Thanks.
It is a holiday for the workers of the world, but we cannot forget that we have a trail to finish. All right, 8:25 through 9:02, then So estimating as the state's case in chief, how long is the defense estimating to present any case that it wishes to do so?
Can I weigh in on that before they speak, Judge? We have historically picked a jury in 3 days at the longest. Twice we did it in 2 days. So my suggestion would be to start on Friday. We could even do openings as early as Thursday, if Your Honor was willing to entertain that. I know that's not the defense's request, but that would be the state's request, just to move it on as quickly as possible.
Well, for the openings only, does the defense have a position concerning this?
We don't want to make openings unless we have a great deal of time after we pick the jury on a particular day. We would prefer to do the openings the next day.
So you're not asking to defer the opening to your case, you just don't want to open on the same day?
It's going to depend, Judge, on the ruling on the additional motion.
All right. On that matter, again, depending on where we're at time-wise, I'll just instruct both parties to be prepared to potentially give their openings. I'm not going to place a time limit on the opening statements, but obviously, well, each party will be the captain of its own ship as to how you will captivate the jurors. Is either party expecting their opening to go beyond 30 minutes?
Depends on your ruling, Judge.
Ms. Calvin?
Yes, I think it could be up to 45 minutes. It's not going to be different than it was previously, but I'm sorry, I don't know how long it was. I would say 30 to 45 is comfortable range, Judge.
Right, as to the defense case, once we are finished with the state's case, how much time are you estimating?
Depends on your ruling, Judge, but anywhere between 4 and 6 days.
4 and 6 days. So that would place us then around the week of September 8th. Concerning any other matters that we can address as the logistics of the trial, I believe we will have rooms available for our family members, both for the victim's family and for the defendant. Do parties anticipate making use of these rooms?
Yes, Your Honor.
Yes, sir.
Right. Please contact court administration. From there, you'll receive information as to how to access the rooms and when they will be made available.
Judge, can I clarify your intentions about when to start testimony?
Go ahead.
You intend to start testimony on the 25th, is that right? With the possibility of openings having already been conducted?
Well, at the latest, if we go into Friday, we're needing to select a jury.
Okay. If we get a jury,
If we get a jury prior to that Friday, on say the 21st, really at that point, there's nothing preventing the testimony from getting started on the 22nd.
okay, so I'll be prepared to start testimony on the 22nd then. And my understanding was, and my subpoenas run through September 5th, but it sounds like we might be extending into the week of September 8th, is that right?
Well, I believe the defense is indicating they might need anywhere from 4 to 6 days.
That's what they said. All right, so we could potentially go through the week of the 8th.
If need be.
All right, I will attempt to get subpoenas out for rebuttal for that week, but I will advise the court that as of right now, those are not out.
We are losing a day because of September 1. But if need be, we can figure out logistically how to make this work for Saturday to continue working. I'm sure you all would like a break, but I'm here. Parties having matters of logistics they need to raise concerning the trial.
Hey, Judge, we're going to have an issue regarding space. We're not all going to fit here. We also don't want our computer screens facing cameras and the audience being able to see what's on our computer screens. I have become very old, and the font size I use is very large, and probably someone in the back row can see what I have on my computer, so we're gonna need to have, I understand we're blocked by this column,
Right.
but we're gonna need to have some kind of setup where we can put our things and our defense not be disclosed ahead of time to the media and blogs and this and that. The second thing is, these microphones used to have the ability that you could touch it and it would turn off.
Mhm.
My client is hard of hearing, so she talks loud. So everything she says is going to be picked up. This one is now set up so you have to press it each time you want to mute it. And, right, press and hold, you gotta hold it down for it to continue to stay muted. And we're gonna ask if the court admin could put it back to the function where we can push it off. I don't think there's gonna be any opportunity in the trial for someone to not pick up on a recording of Mr. Zellman's voice. He's very loud. I tend to be loud too. So it's not gonna be a record issue in our position, but it's certainly gonna be a problem when we're trying to speak to our client about something because it's going to be heard.
Well, in front of the jury, but definitely understand the concern that we're registering with this. It implies what can be done for the microphone on the table. If your client does need to write things down, so that way nothing's being given away, that might be the easiest way for that to be handled, but that requires the microphone. The seating set up in the gallery under the first two rows behind the defense, those are not going to be available to any members of the media. As far as the font size of your computer, if you need to rearrange how you're seated at the table, so if you need a seat on the far left, or my right, your left, so that way your computer can face the ball and no one can see it. I don't really know what I can accommodate you with as far as that font size beyond that.
The problem is the end of the table it's not open. It's the leg of the table. So I don't know if we can add a little something, another table that is the same size.
Well, I've tried a 3 co-defendant first-degree murder trial in this room before, and what we had done was one table was between the column and the bailiff's box. There was a table here and then this table here. I think that if we could put a table to our left, that might be one way of accommodating this thing.
Right. Please make a request to the court admin, we will figure out the best way to try to configure the tables. Ultimately, for what needs to come in with, I believe the state is going to try to, or needs to bring in its equipment, audio equipment.
Yes, Your Honor.
All right. Because of that equipment and how it need to be set up, the tables and how they're configured can't interfere with that, and we'll try to accommodate that as best as possible. This comment as to the audio visual needs of the state, other than what has been used before with the audio setup, is there anything that needs to be addressed?
No, sir, it'll be the same setup with the same company.
All right. Probably then they'll need to get started by the 15th in this room so they can set up all equipment, test the equipment, and if there's any problems, we'll be able to figure out what needs to take place before we actually get started on the 19th. All right. For the media presence that will be here as well, I believe it will be similar rules as it's been in the past. There will be one live video camera, there will be one still frame camera. Obviously, the bloggers and reporters, they are permitted to take notes as if they were print journalists. But the initial rows behind the state, Ms. Kappelman, I assume the victim's family is wishing to appear.
Yes, Your Honor.
All right. They will receive priority seating with regard to how they're positioned in the gallery. After that, it will be free to the public and the press to seat in all areas that are available. Does either party need to be heard concerning those?
Your Honor, we're also going to need space for our client's family and friends who are going to be coming to support her as well. And we would request that they have similar priority seating as the victim's family.
That's what the 2 rows will be behind the defense that will be available to family and friends. Again, similar to last trial, other than the video recording and still frame photography recording, beyond that, no cell phones are to be out recording any other matters or trying to take photos of the witnesses or the jurors. I believe similar in the last trial when Special Agent Jimenez testified, his face was not shown, obviously because of the nature of his past work. The court will just make the same ruling concerning that as well. His face is not to be shown, but of course the substance of his testimony certainly may be reported on by anyone who believes it is newsworthy. During the selection of the jury, the faces of the prospective jurors are not to be shown. Their names are not to be shared. But as far as any biographical type data, such as the composition of the jury, being, for example, 7 male, 5 female, what their professions are, those are certainly able to be reported on by the members of the media and disseminated. But ultimately, what I'm getting at is names and faces, so we don't have any disruption or disturbance during the trial. Do any of the parties have any questions concerning those?
No, Your Honor.
No, Your Honor. One last thing, typically, I don't think I've had a trial with you quite some time. Typically, my paralegal sits with us, so that's another reason why we need that additional table. She also may have some additional people assisting her, and I'll make sure that they're identified as the bailiffs so that there are no issues there.
The members of the direct support staffs may sit on the benches that are behind the attorneys, or if we need to figure out a table configuration for them if we have the space. But the direct support staff is permitted as to both sides. Does either party have anything further to raise concerning the logistics of the trial or any other issues before we finish?
No, Your Honor.
No, Your Honor.
One other matter comes to mind if the attorneys can briefly approach. discussed will be in recess for today. The jury selection will start August 19th at 8:30 in the morning after the initial group of jurors has been qualified. From there, we will move into the pre-screening process as previously discussed. Have a good day, everyone.
Thank you, Judge.
How am I supposed to say that? Talk time with Amy in Boston and Kelly. Time with Amy, Boston and Kelly. Talk 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 time with Amy, Boston and Kelly. Is a member, y'all. Is a member, y'all, to the Gene Deal Show. Talk time with Amy in Boston and Kelly. Talk time with Amy, Boston and Kelly. Talk time with Amy, Boston and Kelly is a member to the Gene Deal Show. Oh, thank you for your membership. Talk time with Amy in Boston and Kelly on the Gene